The Grand Conference Hall at the University of Chicago Law School fell into complete silence. Judge Richard Posner, one of America's most respected legal minds, sat rigidly behind the speaker's podium, his usually sharp eyes now wide with disbelief. Just moments before, he had dismissed Congresswoman Jasmine Crockett as nothing more than a fake lawyer playing politics. But now, as Crockett stood calmly at the microphone with a thick folder of legal documents in her hands, everything was about to change. "Judge Posner," Crockett said, her voice steady and professional, "you question my legal credentials. You suggested I'm just another politician pretending to understand the law. Well, let me share something with you and this distinguished audience that might change your perspective." The tension in the room was electric. Law students leaned forward in their seats. Distinguished professors adjusted their glasses. Legal journalists held their breath. This wasn't just another academic debate between a retired federal judge and a sitting congresswoman. This was about to become a defining moment that would challenge everything people thought they knew about legal expertise and professional respect. What happened in the next 20 minutes would leave Judge Posner speechless, transform how people viewed Congresswoman Crockett's legal abilities, and create one of the most talked about exchanges in modern legal academia. Before we dive into this incredible confrontation, make sure to hit that like button and subscribe to our channel for more exclusive coverage of political and legal confrontations you won't see anywhere else. To understand the magnitude of what was about to unfold, we need to know exactly who these two legal giants really are. Judge Richard Posner had spent over 3 decades as one of America's most influential federal judges. At 84 years old, he had authored more than 3,000 judicial opinions and written over 40 books on law and economics. Known for his sharp intellect and sometimes brutal honesty, Posner had earned a reputation as someone who didn't suffer fools gladly. His colleagues called him brilliant. His critics called him arrogant. Everyone agreed he was one of the most important legal minds of his generation. Posner had recently retired from the Seventh Circuit Court of Appeals, but his influence remained enormous. Law schools across the country still taught his judicial opinions. His books on legal theory were required reading in graduate programs. When Judge Posner spoke about the law, people listened. But Posner also had a problem with politicians who claimed legal expertise. He had spent years criticizing what he called political lawyers, elected officials who used their law degrees to gain credibility, but, in his view, had abandoned serious legal thinking for political convenience. In his mind, there was a clear line between real lawyers who worked in courtrooms and wrote serious legal scholarship, and politicians who happened to have law degrees. On the other side of this confrontation stood Congresswoman Jasmine Crockett, representing Texas's 30th District. At 43 years old, Crockett had built her career as a civil rights attorney before entering politics. She had graduated from the University of Houston Law Center and spent over a decade practicing law in Texas courts. But her transition to politics had led some traditional legal scholars to question whether she was still a real lawyer or just another politician. What most people didn't know, including Judge Posner, was that Crockett had never really stopped practicing law. Even as a congresswoman, she had continued taking on pro bono cases, particularly those involving civil rights and constitutional issues. Her legal work had been largely behind the scenes, but it had been remarkably successful. The confrontation began at a symposium titled Law and Politics in Modern America. The event had brought together federal judges, law professors, and political leaders to discuss the relationship between legal expertise and political power. It was supposed to be a civilized academic discussion. Judge Posner was the keynote speaker, and his topic was the decline of legal thinking in political discourse. His speech had been a systematic attack on what he saw as the politicization of law. He argued that too many politicians were using their legal credentials to make arguments that had more to do with politics than serious legal analysis. When the question and answer session began, Congresswoman Crockett approached the microphone. She had been invited as one of the political representatives, but she wanted to engage with Posner's arguments on purely legal grounds. Her first question was thoughtful and specific, focusing on a recent Supreme Court decision about constitutional interpretation. But Judge Posner's response was dismissive. He suggested that politicians couldn't really understand the nuances of constitutional law because they were too focused on political outcomes. What people in the audience want to know is this: have you ever seen a moment when someone's expertise was completely underestimated? Share your thoughts in the comments below. We love hearing about times when the underdog proved everyone wrong. Crockett tried again, this time asking about federal appellate procedure and how it might affect pending legislation. Again, Posner's response was condescending. He implied that her question showed she didn't really understand how federal courts actually work. That's when Judge Posner made the comment that would change everything. Looking directly at Crockett, he said, "Congresswoman, with all due respect, you're what I would call a fake lawyer. You have a law degree, yes, but you're really just a politician now. You've abandoned serious legal thinking for political theater. I don't think you've been inside a real courtroom or written a serious legal brief in years." The audience gasped. Several law professors shifted uncomfortably in their seats. This wasn't just academic criticism. It was a personal attack on Crockett's professional competence and integrity. Most politicians would have been flustered or defensive. They might have cited their law degree or talked about their political accomplishments. But Jasmine Crockett did something completely different. She smiled calmly, walked back to her seat, and picked up a large folder she had brought with her. "Judge Posner," she said, returning to the microphone, "I appreciate your honesty, and I think this is the perfect opportunity to have a real conversation about legal expertise and what it means to be a practicing attorney in modern America." The room fell silent again. Something in Crockett's tone suggested this wasn't going to be a typical political response. She wasn't going to defend herself with speeches or talking points. She was going to do something that would catch everyone, including Judge Posner, completely off guard. Congresswoman Crockett opened her folder with deliberate care. The thick stack of documents inside was neatly organized with colored tabs and professional binding. This wasn't a political prop. It was the work product of a serious attorney. "Judge Posner, you said I haven't been inside a real courtroom in years. You suggested I don't write serious legal briefs anymore. You called me a fake lawyer." Crockett's voice remained calm, but there was steel underneath. "I'd like to respond to those claims with evidence rather than rhetoric." She pulled out the first document. 3 months ago, I successfully argued before the Fifth Circuit Court of Appeals in Henderson versus Texas Department of Education. The case involved constitutional questions about equal protection and education funding. Here's the brief I wrote and filed. Crockett held up a thick legal document, clearly visible to the audience. This brief cites 47 federal cases, includes original constitutional analysis, and presents novel arguments about the intersection of the 14th Amendment and state education policy. The 3-judge panel accepted our arguments unanimously. Judge Posner leaned forward slightly, his expression shifting from dismissive to curious. "But that's just one case," Crockett continued, pulling out another document. 6 months ago, I represented a group of voting rights activists in federal district court in Martinez versus Dallas County. The case challenged new voting procedures that disproportionately affected minority communities. Here's the motion for preliminary injunction I drafted. She turned to face Judge Posner directly. This motion required extensive analysis of Supreme Court precedent on voting rights, detailed statistical evidence about disparate impact, and constitutional arguments under both the Equal Protection Clause and the Voting Rights Act. The federal judge granted our motion and specifically praised the quality of our legal analysis. The audience was transfixed. This wasn't what anyone had expected. Law students were frantically taking notes. Professors were whispering to each other. Judge Posner sat silently, clearly reassessing the woman he had just dismissed. Crockett wasn't finished. She pulled out a third document, this one even thicker than the first two. "Last year, I took on a pro bono case involving immigration law, Ramirez v. Sta's Department of Homeland Security. The case required complex analysis of federal administrative law, constitutional due process requirements, and international treaty obligations." She held up the brief for everyone to see. This brief is 89 pages long. It includes arguments that had never been made in federal court before about the intersection of asylum law and constitutional protections for families. The district judge called it exemplary legal scholarship and ruled in our favor. Judge Posner was no longer dismissive. His eyes were focused intently on the documents Crockett was displaying. As someone who had spent his career evaluating legal arguments, he could recognize serious legal work when he saw it. But Judge Posner, you didn't just question my recent legal work. You suggested that politicians like me don't understand how federal courts really operate. Crockett pulled out another section of her folder. Let me address that concern as well. She displayed a series of court filings. Over the past 2 years, while serving in Congress, I've filed briefs in federal court in Texas, Louisiana, and here in Illinois. I've argued motions before federal magistrates, district judges, and appellate panels. I've won preliminary injunctions, survived motions to dismiss, and successfully appealed adverse rulings. The silence in the room was deafening. Everyone could see that this wasn't political theater. These were real legal documents from real cases with real outcomes. Most importantly, Crockett continued, I've done all of this work pro bono. I don't take fees for this legal representation because my congressional salary allows me to serve clients who couldn't otherwise afford experienced federal litigation counsel. Judge Posner removed his glasses and cleaned them slowly, a gesture those who knew him recognized as a sign that he was thinking carefully about what he had just heard. Crockett pulled out one final document. Judge Posner, there's one more case I think you'll find particularly interesting. 3 weeks ago, I filed this petition for certiorari with the United States Supreme Court in Thompson versus Federal Bureau of Prisons. She held up the petition, and even from the audience, people could see it was professionally bound and formatted according to Supreme Court rules. This petition presents a novel question about the intersection of the Eighth Amendment and federal prison conditions. It required extensive research into Supreme Court precedent, analysis of circuit splits, and original constitutional theory. She paused, letting the significance of what she had just said sink in. Filing a petition for certiorari with the Supreme Court is one of the most challenging forms of legal writing. It requires mastery of federal procedure, constitutional law, and the specific requirements of the nation's highest court. The petition was accepted for filing by the Supreme Court Clerk's office without any requests for revision or correction. It follows all court rules perfectly and presents arguments that the court has never considered before. Judge Posner was now leaning forward in his chair, clearly engaged despite himself. The audience was completely silent, recognizing that they were witnessing something extraordinary. So, Judge Posner, I want to return to your original comments. Crockett's voice remained respectful but firm. You called me a fake lawyer. You said I had abandoned serious legal thinking for political theater. You suggested I don't understand how real courts work. She gestured to the documents spread before her. I've just shown you evidence of active federal litigation practice, successful courtroom advocacy, complex legal writing, and engagement with the highest levels of the federal judiciary. This isn't political theater. This is the practice of law at the most sophisticated level. The confrontation had completely shifted. What began as Judge Posner dismissing a politician had become a demonstration of legal expertise that few practicing attorneys could match. The question now was how one of America's most respected legal minds would respond to being so thoroughly proven wrong. The silence stretched for nearly 30 seconds. Judge Posner sat perfectly still, staring at the documents Congresswoman Crockett had displayed. Finally, he reached for his microphone. Congresswoman Crockett, he began, his voice notably different from the dismissive tone he had used earlier. I owe you an apology. The audience exhaled collectively. Nobody had expected Judge Posner, known for his intellectual pride and reluctance to admit error, to concede so directly. When I called you a fake lawyer, I was operating from assumptions rather than evidence. That's exactly the kind of intellectual laziness I've spent my career criticizing in others. Posner paused, clearly struggling with his next words. I was wrong, and I was unfair. But Crockett wasn't finished. She had spent months preparing for exactly this kind of confrontation, knowing that her legal credentials would eventually be questioned by someone in the traditional legal establishment. Judge Posner, I appreciate your apology, but I think this moment illustrates a broader problem in how we think about legal expertise and professional competence. She closed her folder but remained at the microphone. You assume that, because I'm a politician, I must have abandoned serious legal work, but that assumption reveals more about our professional prejudices than it does about actual competence. She turned to address the full audience. How many brilliant lawyers are dismissed because they don't fit traditional categories? How many legal minds are underestimated because they work in unconventional settings? Judge Posner nodded slowly. You're right. I fell into exactly the kind of categorical thinking I've always criticized. I saw politician and stopped seeing lawyer. But there's something else, Crockett continued. The legal work I've shown you today represents just a fraction of what lawyers in non-traditional roles are accomplishing. There are prosecutor-turned-senators writing criminal justice legislation based on deep courtroom experience. There are former civil rights attorneys in state governments drafting policies that reflect sophisticated constitutional analysis. She pulled out one more document, this one different from the legal briefs she had shown earlier. Judge Posner, this is a piece of legislation I drafted for Congress, the Federal Court Efficiency Act. It's designed to address some of the procedural inefficiencies you've written about in your scholarship on judicial administration. Posner's eyes widened slightly. He had indeed written extensively about court efficiency and administrative reform. This bill incorporates insights from your book, How Judges Think, and applies them to concrete procedural reforms. It's not just political compromise. It's legal scholarship translated into practical policy. She handed the document to a law student in the front row, who passed it up to Judge Posner. As he scanned the pages, his expression changed again. This wasn't just legislation. It was legislation that demonstrated deep understanding of federal court operations and judicial philosophy. The bill includes provisions for alternative dispute resolution in federal courts, modified discovery procedures based on empirical research about litigation costs, and judicial resource allocation reforms based on case complexity analysis. Crockett's explanation was technical and precise. Every provision is supported by legal scholarship, empirical evidence, and constitutional analysis. Judge Posner looked up from the document. This is serious work. These reforms address real problems I've identified in the federal system. Judge Posner, you've spent your career arguing that law should be practical, evidence-based, and focused on real-world outcomes rather than abstract theory. That's exactly what I'm trying to do. Combine rigorous legal analysis with practical policy implementation. The audience was witnessing something unprecedented. A sitting federal judge, one of the most respected legal minds in America, was being educated by someone he had dismissed minutes earlier as a fake lawyer. But the most powerful moment was still to come. Crockett pulled out her phone and opened a news app. Judge Posner, while we've been talking, I received a notification that I thought you might find interesting. She showed him the phone screen. The Supreme Court just granted certiorari in Thompson versus Federal Bureau of Prisons, the case I filed 3 weeks ago. The court has agreed to hear arguments on the constitutional questions I raised about prison conditions and Eighth Amendment protections. The audience gasped. Having the Supreme Court agree to hear a case is extraordinarily rare. Fewer than 1% of petitions are granted certiorari. It's one of the highest honors in legal practice, recognizing that a case presents issues of national importance and legal significance. Judge Posner stood up slowly. Congresswoman Crockett, not only do I owe you an apology, but I owe you congratulations. Having the Supreme Court grant cert on a petition you personally drafted is an achievement most attorneys never experience in their entire careers. He walked over to shake her hand. I was not just wrong about your credentials. I was blind to work that represents the highest level of legal practice. The audience erupted in applause. Law students stood up. Professors nodded approvingly. Even the journalists who had come expecting a typical political confrontation were clearly moved by what they had witnessed. But Crockett had one final point to make. Judge Posner, I want to be clear about something. I didn't share this legal work to embarrass you or to prove that I'm better than other lawyers. I shared it to illustrate that legal expertise takes many forms and exists in many places. She gestured to the audience. There are brilliant legal minds in prosecutors' offices, public defender organizations, corporate, legal departments, and yes, even in political offices. Dismissing someone's competence based on their current role means we miss opportunities to learn from each other and solve problems together. Judge Posner nodded vigorously. You've taught me something important today, and you've done it with exactly the kind of evidence-based argument I claim to value. Thank you. As the two legal professionals shook hands, the audience could see that something significant had happened. This wasn't just about one confrontation or one apology. It was about challenging assumptions, respecting evidence, and recognizing excellence wherever it appears. The question and answer session continued for another hour, but the tone had completely changed. Instead of dismissive challenges, there was genuine intellectual exchange. Judge Posner asked detailed questions about Crockett's litigation strategy. Crockett sought Posner's insights on judicial decision-making. The audience witnessed two brilliant legal minds engaging with mutual respect and shared curiosity. The aftermath of the Posner-Crockett exchange was swift and far-reaching. Within hours, video clips of the confrontation were circulating on legal blogs, social media platforms, and news websites. The legal community, which rarely pays attention to political figures unless they're nominees for federal judgeships, suddenly found itself talking about Congresswoman Jasmine Crockett. The Harvard Law Review invited Crockett to write an article about the intersection of legislative work and litigation practice. The Yale Law Journal requested a piece on constitutional law and policy implementation. 3 law schools extended invitations for her to speak to students about non-traditional legal careers. But the most significant immediate consequence came from an unexpected source. Judge Frank Easterbrook, one of Posner's former colleagues on the Seventh Circuit, issued a public statement that appeared in the Legal Times. Dick Posner has always valued intellectual honesty above personal pride. His willingness to acknowledge error and learn from Congresswoman Crockett demonstrates exactly the kind of judicial temperament that made him such an effective judge. More importantly, Easterbrook continued, Congresswoman Crockett's legal work represents the best traditions of American advocacy: rigorous analysis, practical application, and service to clients who need experienced counsel. The legal profession is stronger when we recognize excellence in all its forms. The Supreme Court development added another layer to the story's impact. Legal experts began analyzing Crockett's certiorari petition, and the consensus was remarkable. Professor Lawrence Tribe of Harvard Law School called it a masterful piece of legal writing that presents novel constitutional arguments with exceptional clarity and scholarship. Former Solicitor General Donald Verrilli reviewed the petition and commented, "This petition demonstrates the kind of innovative legal thinking that advances constitutional law. The arguments are both theoretically sophisticated and practically grounded." Within a week, major law firms were reaching out to Crockett about potential collaboration on high-profile cases. Public interest organizations began asking her to consult on constitutional litigation strategies. The American Bar Association invited her to join a committee on federal court reform. But perhaps the most meaningful recognition came from Judge Posner himself. 2 weeks after their confrontation, he published an essay in The Atlantic titled "The Dangers of Professional Prejudice." The piece was a thoughtful reflection on how assumptions about competence can blind us to excellence. "I have spent my career arguing that legal reasoning should be based on evidence rather than assumption," Posner wrote. "Yet when confronted with a lawyer whose career path didn't match my expectations, I abandoned evidence-based thinking in favor of professional prejudice." Congresswoman Crockett reminded me that intellectual integrity requires constant vigilance against our own biases. He continued, "The legal work Congresswoman Crockett presented that day would have impressed me if it had been produced by any attorney in any setting. The fact that it was produced by someone juggling congressional responsibilities makes it even more remarkable." The essay went on to praise Crockett's approach to combining legal practice with policy work. She has found a way to use rigorous legal analysis to inform legislative solutions to real problems. This is exactly the kind of practical legal thinking I have always advocated. 3 months after the confrontation, the impact was still growing. The Thompson versus Federal Bureau of Prisons case that Crockett had brought to the Supreme Court was scheduled for oral arguments, with major civil rights organizations filing supporting briefs. Constitutional law experts predicted the case could establish new precedents for prison reform and Eighth Amendment protection. Law schools began incorporating video of the Posner-Crockett exchange into their courses on legal professionalism and career development. Students were assigned to analyze how assumptions about competence can affect professional interactions and how evidence-based arguments can challenge those assumptions. The American Bar Association created a new award for lawyers who combine traditional legal practice with public service in innovative ways. The first recipient was Congresswoman Jasmine Crockett, with the citation reading, "For demonstrating that excellence in legal practice can take many forms and that rigorous legal scholarship can inform effective policy solutions." But the most lasting impact may have been on how the legal profession thinks about non-traditional career paths. Applications to law school increased among students interested in combining legal practice with public service. Young attorneys began seeking opportunities to maintain active litigation practice while working in government or policy roles. Judge Posner continued to reflect publicly on the lessons he learned from the confrontation. In interviews, he emphasized the importance of judging legal work by its quality rather than its context. "Some of the best legal thinking I've encountered in recent years has come from attorneys working in non-traditional settings," he said. "We need to be open to learning from colleagues wherever they practice." For Congresswoman Crockett, the recognition brought new opportunities, but also new responsibilities. She became a sought-after speaker on legal ethics, professional development, and the integration of law and policy. Her congressional colleagues began consulting her on the legal implications of proposed legislation. More importantly, she used her platform to advocate for broader recognition of diverse legal careers. "Excellence in law isn't limited to traditional firm practice or judicial service," she said in a speech to the American Bar Association. "We need to value and support lawyers who find innovative ways to serve clients and advance justice." The Supreme Court oral arguments in Thompson v. Federal Bureau of Prisons were scheduled for the following term, with Crockett arguing the case personally. Legal observers predicted it would be one of the most closely watched arguments of the year, partly because of the constitutional issues involved, and partly because of the unique background of the attorney presenting the case. 6 months later, Judge Posner and Congresswoman Crockett were invited to co-teach a seminar at the University of Chicago Law School on law, policy, and professional practice. The course examined how legal expertise can inform policy decisions, and how policy experience can enhance legal practice. Their first joint lecture drew overflow crowds. Students came to witness the intellectual partnership that had emerged from their public confrontation. The syllabus included cases from Crockett's litigation practice, excerpts from Posner's judicial opinions, and analysis of how legal reasoning applies to legislative and policy challenges. The course became one of the most popular offerings at the law school, with students praising the opportunity to learn from both traditional judicial perspectives and innovative approaches to legal practice. Applications for the following year's class exceeded available spots by more than 10 to 1. In the final class of the semester, Judge Posner addressed the students with characteristic directness. "I have learned as much from teaching this course as any of you have learned from taking it. Congresswoman Crockett has shown me that intellectual curiosity requires humility about what we don't know, and openness to what we might learn from unexpected sources." Crockett added, "Judge Posner has demonstrated something equally important, that intellectual integrity means being willing to change our minds when presented with evidence that challenges our assumptions. That's the foundation of good legal reasoning and good policy making." The transformation from confrontation to collaboration became a model for how professional disagreements could lead to mutual learning and improved outcomes. Legal ethics courses began using the Posner-Crockett exchange as a case study in how to handle professional criticism constructively and how to respond to unfair assumptions with evidence rather than defensiveness. A year after their initial confrontation, the American Bar Association honored both Judge Posner and Congresswoman Crockett with special recognition for their contributions to legal education and professional development. The award citation noted their willingness to learn from each other and their commitment to evidence-based evaluation of legal competence. The story of their confrontation and subsequent collaboration continued to inspire lawyers, judges, and law students. It demonstrated that the legal profession is strengthened when it remains open to diverse forms of excellence and when practitioners are willing to challenge their assumptions about competence and professional worth. Most importantly, it showed that even the most uncomfortable professional confrontations can become opportunities for growth, learning, and mutual respect when handled with intellectual honesty and genuine commitment to excellence in legal practice. Thank you for watching this incredible story of professional confrontation, personal growth, and ultimate collaboration. If this analysis opened your eyes to the importance of challenging assumptions and recognizing excellence in unexpected places, please hit that like button and subscribe to our channel for more exclusive coverage of legal and political developments that matter. Share this video with anyone who needs to hear about the power of evidence-based arguments and intellectual humility. What moment in this confrontation resonated most with you? Leave your thoughts in the comments below. We read every response and love hearing your perspectives on these important, professional, and constitutional issues.